Good evening. My name is Renata Ferrari, and on behalf of the Board of Student Advisors and Dean Clark, I would like to welcome you to the final round of the 86th Annual Ames Moot Court Competition. This evening, the United States Supreme Court will hear arguments in Willard Beach Golf Resort versus Champions Greens. The case involves the issue of whether the layout of a golf course can serve as the course's trademark, protected under a variation of trademark law called trade dress. The record was written by the Ames fellow, Sean Carnathan. Representing the petitioner is the Charles Hamilton Houston Memorial Team, composed of Rachel Clark, Russell Robinson, Guhan Subramanian, and George Wang. Oralists for the petitioner are Canon Shanmugam and Amanda Tyler. Representing the respondent is the Justice William J. Brennan Jr. Memorial Team, composed of Sarah Kotler, Mona Matrani, Nancy Potts, and Kevin Taruya. Oralists for the respondent are Laura Flint and Daniel Pariser. Presiding as Chief Justice is the Honorable David H. Souter, Associate Justice, United States Supreme Court. Joining him are the Honorable Phylllis A. Kravitch, United States Court of Appeals for the 11th Circuit, and the Honorable Bruce M. Selya, United States Court of Appeals for the First Circuit. Please hold your applause until after all oralists have finished, remembering that the petitioner has reserved 3 minutes for rebuttal. Also, please refrain from flash photography during the argument. The judges will pose behind the bench for photos a few moments before the argument begins. Best of luck to both teams, and enjoy the argument.
Before the Honorable, the Supreme Court of the United States, I admonish to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
We'll hear argument this evening in number 98-001, Willard Beach Golf Resort against Champions Greens. Mr. Shanmugam.
Thank you, Mr. Chief Justice, and may it please the court. Good evening. My name is Canon Shanmugam, and I represent the petitioner, Willard Beach Golf Resort, in this appeal. I will be addressing the inherent distinctiveness issue in this case. My co-counsel, Amanda Tyler, will address functionality. Willard Beach Golf Course was designed in 1893 by the renowned golf course architect William Morris and is widely regarded to be his masterpiece. Willard Beach has long been considered one of the top golf courses in the country and has frequently hosted the nation's most prestigious golf tournaments. In 1995, Respondent began constructing a golf course that intentionally copied Willard Beach in exact detail. Upon completion, Respondent then promoted its course as, quote, a precise replica of the nation's most famous and most challenging course. In 1996, Willard Beach commenced this action, alleging infringement of unregistered trade dress under Section 43A of the Lanham Act.
Why did it do it? We have on the record here a finding in the district court, which has not been challenged, that confusion is likely. And I will be candid to say that I don't understand what that finding represents, and I don't understand what your client is worried about. And perhaps one could say, well, that's academic at this stage, but there are choices to be made here of standards, and it strikes me that the choices we make perhaps should be driven in part by a perception of what your client is worried about, and I don't know what it's worried about.
Your Honor, what my client is worried about is the danger that tomorrow morning, if this court rules in favor of the respondent, we're going to wake up and find 100 replicas of the Willard Beach course around the country. Without this protection, Willard Beach can be copied at will.
The champion didn't challenge before the Court of Appeals that finding that there was a likelihood of confusion, did it?
That's right, Your Honor.
What does it mean?
My understanding of the lower court's decision, Your Honor, is that it found likelihood of confusion. Now, there's no explanation for what ground the court, on what ground the court relied.
Confusion as to what, counsel?
Confusion, presumably, as to sponsorship. I think it's probably very unlikely that someone who is playing the Champions course would actually think, whoa, we're at Willard Beach. But they may very well think that they're playing a course that is sponsored by Willard Beach.
Why would they think that? I take it from what you've said so far that you would accept the fact that the people that we ought to sort of have in mind when we talk about confusion are the people who are likely to play on the Willard Beach golf course.
That's right, Your Honor.
All right. Now, what reason is there to think that the people who play on the Willard Beach golf course, who are privy to the same history that you have pointed out to us already, are likely to think that these supposed lookalikes, be they in the hundreds or less numbers, are in fact sponsored by whatever the corporation is called, the Willard Beach Golf Resort, Inc. Corporation? That seems highly unlikely to me.
Well, again, Your Honor, it's certainly possible that people playing these courses may be in doubt as to whether Willard Beach is sponsored.
Well, but you've got to have more than possibility. I mean, what we've got here is Willard Beach that costs $250 to walk around the golf course, and Champions that cost $40. The people who play Willard Beach are not likely to be confused as to who is sponsoring a $40 golf club, are they?
Your Honor, I think that goes to the question of competitive effect, which is certainly very vital to the functionality inquiry, as my co-counsel will address. Certainly as well.
Well, it seems to me that it also goes to the issue that you're going to address, because one of the arguments that you're going to address here is whether we have a comparatively formalistic test, Abercrombie, or whether we have a test that looks more to the actual effects of confusion. And it seems to me that we perhaps ought to bear in mind, as it were, what the market is, that these issues are being addressed in, and what the people in that market are likely to think. So I think it bears on your issue too.
Mr. Chief Justice, I would say in response to that I think that the role of the Willard Beach Golf Course in the market is taken into account by the Abercrombie test, specifically by the formulation of the Abercrombie test laid down by the Court of Customs and Patent Appeals in Seabrook, which looks to whether a product configuration is unique or unusual. That in turn necessitates a comparison with other layouts in the market.
Well, let's assume that it is unique, and let's assume, as we have to for this case, that it is copied right down to the last blade of grass by the champion course. The people who are paying $250 to go around Willard Beach, it seems to me, are highly unlikely ever to assume that the $40 championship course is being sponsored by the same people who sponsor or own Willard Beach.
Well, Your Honor, I would just say that as regards the question of likelihood of confusion, it's certainly an open issue as to why the lower court made that finding. Presumably one of the factors it took into account was the defendant's intent, which has traditionally been one of the factors considered in that inquiry. But beyond that, I really can't speculate as to why the court did so. However, I would say that the likelihood of confusion inquiry is certainly the proper province for the concerns that you're articulating.
What significance, if any, counsel, does it have that we're dealing here with an athletic facility?
None to my knowledge, Your Honor.
But isn't it true that athletic facilities have a tendency to emulate one another? Camden Yards gets constructed in Baltimore. It's a great success. So every other new baseball park now looks like Camden Yards, and the natural association isn't that the Baltimore Orioles sponsor Jacobs Field in Cleveland, all right? But that perhaps the same architect or the same designer is involved, but there's no source identification.
Justice Selya, it may very well be that if, say, the Kansas City Royals were to build a new stadium tomorrow, they would build a stadium that exactly copied Camden Yards. The Camden Yards would have a case for trade dress infringement. The inquiry under Abercrombie really looks at two things. First, it looks at the relationship between the product configuration and the underlying product in determining whether something is sufficiently distinctive. And that's really the goal of the Stewart Hall inquiry. And under Seabrook, it looks at a very related thing, which is the relationship between the product configuration at issue and products generally in that market. Now, whether Camden Yards is sufficiently distinctive to meet both of those standards is an open question. To the extent that it were, however, certainly it would be able to obtain protection.
Well, in what way, other than the of the redbud and trees, dogwood, is this course that distinctive from other golf courses?
Justice Kravitch, every hole of Willard Beach's layout has features that are to some extent distinctive. I would point the court to two holes in particular. First of all, I would point the court to the 10th hole as you refer to, which has long been considered Willard Beach's signature hole, and that's the Camellia hole, and it's found on page 24 of the joint appendix. There, among the distinctive features, and this is by no means an exclusive list, are the dogwoods and redbuds to which you refer, which line both sides of the fairway and create this impression of Gothic spires, as Willard Beach's expert adverted to in his testimony. Further, the precipitous drop in the fairway of some 9 stories from the top of the tee to the bottom of the green, and finally, the impression of a snowstorm that's created when the dogwoods are in bloom. The principal focus of this court's inquiry, no matter which test it accepts, is to determine whether a golfer, say standing on that tee, would be likely to see these features as identifying Willard Beach. To give just one other brief example.
Well, excuse me, is that correct? Isn't the issue whether they would be likely to identify the course as having been brought to them by the same people who brings them Willard Beach?
That's certainly true, Your Honor.
But it's when we talk about origin, we're talking about something other than the course itself, something other than the object configured, are we not?
That's certainly true, Mr. Chief Justice. It's the source, and it isn't that consumers need to know particularly what that source is. It's just to identify that it's the same source that produces the original product. Now, turning, if I may.
Is that principle true? Is it your claim that each and every hole on this golf course is distinctive and cannot be replicated by a competitor?
Justice Selya, the 11th Circuit in John Harlan stated that trade dress is defined as a total image of the product, and that's a definition that has been accepted by a variety of circuits, including and also accepted by this court in 2 Pesos. However, in engaging in that inquiry of looking at the total image of the product, as a number of courts, including the Second Circuit in the Landscape Forms case, have noted, it's necessary to look at particular individual features. Certainly the primary evaluation is indeed of the configuration as a whole, and in this case, because the entire golf course has been copied, it's really the distinctiveness of the entire golf course that's at issue.
And I take it that when you speak of distinctness and you talk in terms of visual imagery, what you're really doing, and sensibly enough, is using that sort of visual description as really a surrogate for the challenge that the course offers to golfers. It's the playing experience, which is the essence of what you claim as being improperly duplicated. Is that fair to say?
Well, Chief Justice Souter, it's the identifying features of the course. And as a number of courts have noted...
But golfers only care about that because they want to play golf. So that the identifying features of the course really go to what it's like to play in that course. Isn't that the point?
That's certainly true to some extent, but at the same time, there's undoubtedly a certain cachet to playing these famous golf courses. Certainly people fly off every year to St. Andrews just for the value of saying that they've played St. Andrews.
Is there anything in the record to show that that same cachet applies to the Champion course, which is not as expensive and not as famous?
There's certainly no evidence that that cachet attaches to the Champions course. There's certainly ample evidence suggesting that it may very well attach to my client's course. For example, the fact that my client's course has been rated among the top 3 courses in the country twice in the last few years. That evidence alone would suggest that it does.
And has Champion been rated anywhere near there?
There's no evidence in the record that it has been. Now, turning to this court's decision in 2 pesos, it's Willard Beach's position that this court's decision and its reasoning in particular really necessitates the application of the Abercrombie framework.
Was that an issue in 2 pesos?
The primary issue in 2 pesos was certainly whether a trade dress of any variety can be inherently distinctive without secondary meaning.
Well, did anyone raise the issue saying you ought to apply Abercrombie rather than Duraco or Duraco, however you pronounce it?
The issue was not presented in the briefs, Your Honor. It was raised on oral argument. But the language that this court used in the 2 pesos decision seems to suggest that its application of the Abercrombie framework extends to product configurations. First of all, this court explicitly approved of the lower court's application of Abercrombie, saying that it was quite right to follow the Abercrombie classifications. Further, this court noted that there was no basis in the language of Section 43A of the Lanham Act for distinguishing between any kind of trademark and trade dress. Indeed, when Congress amended Section 43A in 1988, it afforded much of the same protection to unregistered trademarks and trade dress as it historically has afforded to registered trade dress. Further, the layout of the restaurant at issue in 2 pesos, which was the trade dress being discussed, more closely resembles a product configuration than packaging. Indeed, it's difficult to see how the concept of packaging can apply in the restaurant context at all.
Well, in 2 pesos, wasn't it the decor as much as it was the layout?
It was the
that was
decor.
involved?
It was the decor, Your Honor, though I think it was probably a combination of the two. The features that the court referred to were the painted exterior of the restaurant, the use of brightly colored awnings, and the use of umbrellas. However, this doesn't really constitute packaging in any traditional sense of the term. It isn't as if someone going into the restaurant will tear off these features and discard them like they do ordinary packaging. Further, to the extent that this court accepts Respondent's analysis of the case, reading this layout as packaging, it's difficult to see how the layout of a golf course should be treated any differently. And a number of commentators, most notably Professor Dinwiddie, have suggested that for precisely that reason, the layout of a golf course should constitute packaging.
Of course, the odd thing is that at least in 2 pesos, whether you call it packaging or not, the business of the restaurant was to provide something within that framework, call it package or not. The odd thing here is that the golf club doesn't provide anything except the setting. The setting is immobile, and therefore there's just something basically odd about talking either of packaging or perhaps even talking about Lanham Act application for a physical facility which, so far as we know in the relevant market, is not subject to franchise-like duplication. And it seems to me that it raises a question whether there should be any Lanham Act application here at all.
Well, Mr. Chief Justice, I think the 2 situations are actually quite similar. In both cases, you have some sort of physical framework at issue. And in both cases, you're consuming a service when you go to a restaurant or you go to play a golf course. And that service
the service is different from the packaging in the restaurant, whereas the service is the packaging here. The service is the golf course.
That's certainly true to some extent, but the features that Willard Beach is seeking to protect are not features that are essential to every golf course. That's precisely why they should be protected.
Well, except that when you're talking about, take the 2 pesos situation, what you're worried about is that people see the surroundings, the neon stripes and the interior decoration and so on, and they say, I have reason to expect that I will get the same food that I got the last time I was in a place like this, and if they don't, they're going to say, all of the people who serve food in places like this are going to the dogs. That's not the way it works in a golf course. All the golf course provides is, as it were, the restaurant but no food. You bring your own food, as it were, to the golf course.
Mr. Chief Justice, I disagree for the sole reason that in identifying a golf course as Willard Beach's, people may rely on Willard Beach's reputation, say, in maintaining the golf course and so forth. And to that extent, it is similar to relying on McDonald's, say, in the restaurant experience for getting the same kind of food every time you go there. I see that I'm out of time. Thank you.
Thank you, sir. Ms. Tyler?
Mr. Chief Justice, and may it please the Court, good evening. My name is Amanda Tyler, and I will be discussing the functionality question. Your Honors, this Court held in Qualitex that a product feature is functional if it is essential to the use or purpose of an article, or if it affects the cost or quality of an article. That is, if exclusive use of the product feature would put competitors in the market at a significant non-reputation-related disadvantage. Under this test as applied in the trade dress inquiry, which looks at the product as a whole, Respondent has no functional need to copy Willard Beach's layout in its entirety. Notably, of the 13,000 other golf courses in the United States, not one has had to copy even a single hole from Willard Beach's course in order to compete.
Yeah, not one is as good a golf course, according to you.
No, Your Honor.
Maybe they should have been copying.
There are many great golf courses in the United States, Your Honor. For example, the U.S. Open is played on over a dozen different courses. And Willard Beach has not in some way designed the sole great golf course. There are indeed an infinite number of ways in which a golf hole can be configured, as the district court found.
There are, but let me go back to that. I don't know that we have any reason to believe, either from what we're told in this case or what we know from our common experience, that there is an infinite number of ways to design a really challenging golf course, a very good one. Obviously, I think it's obvious, there are fewer ways to design a really championship course than there are to design a mediocre course, or there would be more championship courses and fewer mediocre ones, so that there does seem to be some kind of a limitation involved here, and I don't see how you can speak about infinite variation if you're going to, at the same time, trumpet the quality of your client's product.
Well, Your Honor, the quality inquiry asks whether the first user of the configuration has built, in this case, a course that is substantially better in operation. It is the most effective or most efficient way of configuring the course. And in this case, that simply isn't the case. There are many great courses in the United States. And the ramifications of this case go well beyond simply whether champions can copy Willard Beach's trade dress. When Congress passed the Lanham Act, it believed that the trademark regime would in fact enhance competition. The Senate report accompanying the 1946 Act, that was quoted at length by this court in 2 pesos, opened with the statement, quote, "Trademarks indeed are the essence of competition because they make possible a choice between competing articles by enabling the buyer to distinguish one from the other." Not only will many other courses be able to copy Willard Beach's course layout in its entirety come tomorrow if the court rules for Respondent, but the incentive to create future great courses will be greatly diminished, if not eliminated. It is very expensive to build a great golf course today because you have to hire a great golf course designer. Designers of the day, one of the greatest, Jack Nicklaus, charges a retainer fee of $1 million. So it is no cheap endeavor to enter into building one of these. However, people are still doing so. There are many great courses being built currently. But a rational economic actor would not invest the time and resources in designing a great course and building it if he or she knew that immediately upon completion, a free rider could enter the market and co-opt that design and sell it at a cheaper price, ultimately and possibly pushing that first user out of the market.
So your theory, counsel, is that any person who creates a golf course, since golf courses are infinitely variable, gets complete protection for that particular course, and no one can duplicate any golf course?
Well, Your Honor, in order to secure trade dress protection, the first user of the course design would have to also surpass the likelihood of confusion and the inherent distinctiveness prong. And as the Chief Justice noted earlier, the likelihood of confusion prong is very difficult to surpass in this area. And
Well,
indeed-
I don't know that it is. I mean, we start with the premise of Justice Selya's question that we're talking about real duplicates. And what we have in the record here is an indication that golfers who were shown photographs of these duplicates couldn't tell one duplicate from the other. It seems to have been quite easy to get to the point which seems to have satisfied the district court here. And I suppose it would be equally easy taking the premises of Justice Selya's question in every instance.
Well, Your Honor, first of all, the course would still have to prove that it is unique and inherently distinctive.
But according to your argument, every course is unique because there is infinite variation, and no course up until Champions has replicated your course. There are 13,000 golf courses. Most of them are probably, I doubt if other than these two, you're going to find any two that are identical. So why isn't each one of them susceptible to proprietary protection?
Well, Your Honor, first of all, we can look for reference to the Tour 18 case out of the Southern District of Texas, where the golf course there had taken from 18 famous golf courses a hole from each course. And in that case, 3 holes were at issue, and all were deemed non-functional by the court because of the existence of an infinite number of variables.
But here
Moreover,
you took all 18 holes, didn't you?
that's right, Your Honor. And so this
Including
case...
the redbuds and the dogwood trees?
Yes, Your Honor. And in this case, actually, the court's opinion would not be broad. It would actually sweep very narrow. And that is because it would only say that a competitor in the market cannot copy a golf course built in precisely this manner. And in order to build a competitive golf course, it is not necessary to have the 4th hole in the shape of a saddle, or to have a creek running alongside the 13th hole, or to have, as Your Honor has referenced, dogwoods and redbuds on the 10th hole. And indeed...
It isn't, but the question, I think, is, should we look at golf courses defined simply as places where for 18 consecutive attempts you can try to hit a ball from the tee to the hole? Or do we look at golf courses defined in a more exacting way with reference to the particular qualities of particular courses? And what we decide to be the relevant golf course on that definitional issue will decide how we come out, I presume, on the issue that you're arguing. Why should we look at golf courses with particularity as distinct from looking at golf courses in a very general kind of way, just 18 successions of these playgrounds?
Well, Your Honor, Willard Beach is not seeking protection for all 18-hole golf courses with 18 fairways and 18 tees. It is only seeking protection for a golf course that is made in this particular way, with pines on the 10th hole that give the impression of Gothic spires.
And the value of which depends upon these particular configurations, doesn't it?
Well, Your Honor, some of these, and in fact several of these products, were designed and chosen in part for their aesthetic appeal. Now, under Respondent's
Which makes
reasoning,
them unique.
it makes
as I
them
think you
unique.
put it.
Yes, Your Honor.
If their value is unique, why should we look, as it were, at infinite variety as their alternative?
It's unique.
Why should we, in fact, assume they have any alternative at all?
Well, Your Honor, it's unique in the aesthetic sense. It is a pleasing alternative design among many available.
Isn't it unique in a playing sense? Does anybody else have to make the golf ball turn the corner in exactly the way on a given hole that they have to do to play successfully at your course?
No, Your Honor. There are, as the district court found, an infinite number of ways to configure a golf hole, and it simply is not necessary in order to build a great golf course to have a creek running alongside the 13th hole. The inquiry that this court framed...
But having the creek running alongside the 13th hole creates a playing hazard, which is unique to this course. Other courses have hazards, but each hazard that you've got is unique. The snowstorm effect of the blossoms, right, affects the vision of the golfers, the ability to see the ball when they're striking it. So it gets back to the Chief Justice's question, all right, that isn't the uniqueness really an argument for functionality, not against it?
Well, Your Honor, first of all, we're not saying that no one can ever use a creek as a hazard on a golf course. We're just saying that they can't build the golf course that looks identical to Willard Beach. Secondly, this court held in Qualitex that the functionality inquiry should not discourage the creation of pleasing designs because it is open to competitors in the market to do the same. And indeed, that is the very goal of the Lanham Act, among several. Congress hoped to create incentives for the investment in a distinctive mark. And it
But
hoped...
doesn't your argument then imply that any time a producer comes up with the product innovation, that competitors have an uninhibited right to copy?
Your Honor, that is the proper regime of the patent law, and it rewards technological innovation, somehow configuring the product in the most efficient manner or making the product work better. There are many different ways to build a great golf course. We have not somehow designed the best golf course in terms of making it work better.
No, but in terms of the usual product, there's if you will, there's a result at the end of the line, which can be the same by many different routes. But the object of a golf course is not simply to get to the 18th hole. The object of a golf course is to be able to meet a certain number of challenges on the way to getting to the 18th hole. So the analogy with the ironing board cover does not work. And it suggests, the failure of the analogy suggests that there is something functional about these features, which you perhaps quite rightly tout as unique, or at least arguably so, which is not the case with respect, say, to the color of the ironing board.
Right, Your Honor. However, the trade dress inquiry looks at the product as a whole, and this court and other courts have held that even if it includes some functional features, that does not preclude a finding of non-functionality. The question is whether...
Well, where do we draw the line on your theory between what is functional and what is not?
Well, Your Honor, first of all, the choice of flowering trees versus normal trees is purely an arbitrary choice. It's not necessary to have flowering dogwoods as opposed to, I don't know, pines or some other kind of tree.
But as Justice Selya said, when they're out in bloom, it's harder to play the course. That affects not the product, because you're not so much giving a product, it affects the service. The service is different. Something different is provided to the person who wants to play that golf course.
I guess I would just come back to the question that was posed by this court in Qualitex, and that is whether designing the product in this particular way actually makes the product work significantly better so that competitors in the market could not compete without the ability to co-opt the design.
Well, apparently, this particular product does work quite well from the number of prizes and plaudits that this golf course has earned.
Again, Your Honor, there are many other great courses in the country.
Is there any other course that has won this number of accolades? I saw nothing in the record about that.
Well, in the record, Your Honor, the course was rated first in the country one year and third in the country another year. The teaching, I guess, or the implicit teaching would be that there were other great courses ranked 1 and 2, and the other years 3 and 4, just go on. Under Respondent's logic, any feature that contributes to the commercial appeal of the product would be deemed functional, and the product as a whole would be deemed functional. The problem with this argument is that ultimately it argues for an aesthetic functionality test, which
Well, it may in the case of golf courses, but not in the case of ironing boards. In other words, they're making that argument. I don't know that they are saying that every feature of challenge or every visual feature is in all times and with respect to all products functional. Their argument is that it is with respect to a golf course in which it is the very fact of the challenge and the loveliness of the surroundings that a person is there in the first place.
Well, Your Honor, the problem with this argument is that, as the Second Circuit said in the Sports Act and the Third Circuit said in King Corp., the more appealing the design under that logic, the less protection it would receive. But indeed, as this court has recognized in numerous trademark and trade dress cases, Park and Fly, 2 Pesos, Inwood Labs, and Qualitex, the goal of the Lanham Act is to encourage the creation
Any
of
golf course
distinctive
cases?
designs. No, Your Honor,
No.
because no other golf course has ever been copied wholesale.
Then why isn't it legitimate, not to draw an arbitrary line between golf courses and everything else, but why isn't it legitimate, for the sake of the argument that your opponents make, to draw a line between packaging and configuration issues in which the configuration is the only thing that is provided, and on the other hand, packaging and configuration issues in which the packaging, in effect, brings something else with it. It either brings a product or it brings a further service, as in the case of Taco Bell. Why isn't that a sensible line to draw? And of course, if it is drawn, why don't you lose?
Well, Your Honor, because this court in 2 Pesos echoed what Congress said when it amended the Lanham Act in 1988, and that is that it wanted trade dress to be treated in the same way as the trademark laws. Moreover,
yeah, but maybe it simply does not fit the situation of the golf course. One of the issues which is, I think, subsumed by the questions here, though not baldly stated, is whether the Lanham Act should apply here at all. And I'm asking you how to draw lines. I've suggested one line that can be drawn. If you can suggest a different line to be drawn that would protect you and allow the Lanham Act to be applied, I'll listen to it.
Your Honor, I see that I'm out of time
You may
to answer
answer.
the question. I will certainly try. The goals of the Lanham Act definitely come into force here. Congress clearly wanted to provide the incentive to create distinctive marks, or in this case, distinctive designs. Congress wanted to encourage the investment in product goodwill and maintenance of product quality, and it also wanted to prevent consumer confusion and deception. All of those goals are served by extending trade dress protection in a case such as this, and not allowing the trade dress to be copied wholesale. For all of the foregoing reasons, we respectfully request that the Ames Circuit be reversed.
Thank you, Ms. Tyler. Mr. Parisa? Is it Parisa or Parisa?
Parisa.
Parisa.
Mr. Chief Justice, and may it please the Court, my name is Daniel Pariser, and along with my co-counsel Laura Flint, I represent the Respondent, Champions Greens Incorporated. I will be addressing the issue of whether the Circuit Court of Appeals applied the proper legal standard in determining that the Willard Beach golf course layout does not qualify as inherently distinctive trade dress. My co-counsel will be addressing the non-functionality issue. For a product configuration to be protectable trade dress under Section 43A of the Lanham Act, it must be distinctive. Because the Willard Beach golf course layout has not acquired secondary meaning, it can only meet the distinctiveness requirement if it is deemed to be inherently distinctive. Willard Beach cannot meet this requirement. The Court of Appeals properly rejected the Abercrombie framework for assessing inherent distinctiveness as inadequate for product configuration cases.
Mr. Pariser, in your brief, you tell us that we're to review the Court of Appeals' determination on inherent distinctiveness under the clear error standard. Do you
Yes.
stand by that?
Yes, I do, Your Honor.
And what's your authority for that?
The authority for that, Your Honor, is we adopt substantially a similar test as the court below. And the question of inherent distinctiveness is an ultimate issue of fact. And under Rule of Civil Procedure 52A, an issue of fact is reviewed under the clearly
An
erroneous
issue
standard.
of fact as determined by the trial court is reviewed for clear error. But is there any authority that a statement or conclusion as to a fact made by an intermediate appellate court is then reviewed on further appeal for clear error?
Well, first of all, Your Honor, I'm not certain that Rule 52A makes a distinction between trial and appellate courts. In this case, this court has stated, for example, in the Bose Corporation versus Consumer Unions case, that a circuit court may institute its own findings of fact.
That's true in the First Amendment area. That's Bose.
Yes, Your Honor.
Are there First Amendment implications to this case? That seems to fit about as well as the Lanham Act.
No, Your Honor. When a circuit court changes the applicable legal standard, it is appropriate and within that court's discretion to insert its own findings of fact. It's, for example, serves goals of judicial efficiency. If the record is relatively short and it's mostly composed of documentary
But why
evidence.
should another appellate court defer to those findings?
It's premised on judicial efficiency goals, Your Honor. There's no real reason to encourage the circuit court to have to remand to the district court if it has before it a short record composed of documentary
I
evidence.
suppose if we're really interested in efficiency, we could do away with oral arguments. All right, I didn't mean to get you off your main.
It's quite all right, Your Honor.
It's a good thing he didn't mean to. I'd hate to think of what would have happened if that had
The Abercrombie classifications are inadequate for product configuration cases. The Abercrombie system was developed in the word mark context to describe the relationship between the mark and the product. In the product configuration case, however,
But we used it in 2 pesos.
that's correct, Your Honor. At that time, the Dorico decision had not been decided, and the issue of which standard to apply was simply not argued or briefed before the court. The 2 pesos case held only that trade dress was capable of being inherently distinctive. It did not address the proper standard for inherent distinctiveness that should be applied to trade dress cases, or especially product configuration cases in particular.
All right, go for the jugular on this one. What is the most significant aspect of Dorico that, in effect, argues for our adoption of it here?
It's a difficult question because really there are 2 key aspects, and the unusual and memorable prong and the conceptual separability prong are both necessary requirements of any test. If Your Honor really wants to get at perhaps the most and vital part of the test, I would say that the conceptual separability requirement is key because, as Your Honor alluded to in oral argument with Mr. Shanmugam, the goal of the Lanham Act is to protect the goodwill of the source, not of the goods itself. And when a consumer perceives a good such as a golf course merely as a useful item, they're not going to perceive or link that to any particular source until that item has acquired secondary meaning in the marketplace. So the conceptual separability requirement ensures that consumers will view a particular product feature or configuration not as a useful component of the good itself, but rather as a separate and independent signifier of origin. However, the unusual and memorable requirement is also a necessary requirement of the Dorico test. Neither one by themselves are sufficient. For example, an example can be taken from the case of application of David Crystal Incorporated, which dealt with a plaintiff attempting to assert trade dress in the parallel blue stripe bands on men's sports socks. The bands could be said to be conceptually separable because they weren't related to the nature of the goods of the sock itself. However, such a feature would not be likely to be regarded as a distinct indicator of source because it's simply a form of common ornamentation in the industry. So really both the conceptual separability requirement and the unusual and memorable requirement are necessary for the inherent distinctiveness.
Doesn't the memorable requirement just get us back into the secondary meaning distinction and do away with what we said in 2 pesos, that secondary meaning was not a necessary requisite of distinctiveness, inherent distinctiveness?
No, Your Honor. In large part,
What's the difference between something having secondary meaning and something being memorable?
Memorable means that it's likely or apt to be remembered upon immediate entry into the marketplace. It does not require, for example, a consumer survey of what percentage of consumers already recognize a particular feature as a source identifier. The key distinction between inherent distinctiveness and secondary meaning is that inherent distinctiveness looks at a product immediately upon market entry. It only looks at the inherent characteristics or nature of the good itself.
Well, doesn't the requirement of conceptual separability sort of conflate the inherent distinctiveness inquiry with the functionality inquiry?
No, Your Honor. They're 2 distinct.
Well, it requires that consumers can separate in their minds the symbolic nature of configuration with its useful nature, doesn't it?
It does, Your Honor. But there is a distinction between consumer perception and how competitors need to have a right of free copying and also conflict with the patent laws and policy. So while often a product feature that is not conceptually separable will be functional, it's not necessarily always the case. An example would be a case called Application of Shakespeare Company, which involved a fishing rod that had a distinctive spiral marking along the length of the fishing rod. The spiral marking was, however, the result of a particular manufacturing process. So while consumers may have regarded it as a distinctive marking, it was in fact an item that really contributed to the cost or quality. It made the fishing rod more resilient, for example. So there are instances where the two inquiries are entirely distinct. Your Honor, Willard Beach attempts to ask this court to implement the Abercrombie standards in order to retain consistency. But in effect, the tests that they urge are entirely distinct from the original Abercrombie classifications. The Stewart Hall test, for example, which asks whether a particular product feature is only tenuously related to the nature of the product, simply bears no resemblance to the original Abercrombie classifications of suggestive, descriptive.
But counsel, in a trade dress situation, I think everybody understands that Abercrombie has to be adapted to the trade dress arena. And it is true that Stewart Hall and Seabrook, for example, take slightly different adaptations of Abercrombie. But why does that need for adaptation or the possibility that reasonable people could make different adaptations? Why does that argue for simply scrapping the Abercrombie test and pulling a test like the Third Circuit did out of thin air?
It doesn't argue in favor. It simply goes to the issue of whether this court should simply retain Abercrombie because it has done so in the Wardmark context. And when that rationale...
Doesn't it say that if trade dress and trademark are really to be treated alike, to the extent that the law can treat them alike, that what we should be doing is not considering whether to discard Abercrombie, because discarding it would ensure that the two were treated differently, but that we should be searching for the most workable adaptation of Abercrombie to the trade dress arena.
I think Your Honor is correct. And in fact, Dorico is not an entirely novel test, and it does have its roots in the ideas behind the traditional Abercrombie test. For example, the conceptual separability requirement is similar to the Wardmark context. A word that also serves a useful function to describe the nature and characteristics of a good is a descriptive word, and it's not inherently distinctive. It can only be protected upon a showing of secondary meaning. So similarly, in the product configuration context, when a consumer views a product feature or configuration as primarily serving a useful value as part of the product itself, it must await secondary meaning before it is protected.
Well, are you saying, in effect, that in fact Judge Selya's suggestion is very well taken, that the only thing that Dorico really is adapting Abercrombie to the peculiar circumstances of these configuration cases?
Well, it does differ in some respects. First of all, it dispenses with the Abercrombie labels like descriptive, suggestive.
Yeah, but in substance. Is it doing anything more in substance?
It does, Your Honor. It also includes the unusual and memorable requirement, which, while not rooted in the Abercrombie
what's
test,
different about that? Isn't that simply another way of saying the same thing that Abercrombie is saying when it talks about the categories of the suggestive and the fanciful and the arbitrary and so on? Different words, but getting at the same thing, isn't it?
Perhaps it is. Perhaps it is somewhat, Your Honor. And we would not.
If that's the case, then why isn't this basically just an adaptation, and perhaps a good adaptation of Abercrombie?
Perhaps it is, Your Honor. And if so, I would ask.
Well, do you think it is?
I do think it has close analogies to Abercrombie in the Wardmark context.
Then don't we have to reverse?
Not at all, Your Honor.
Well, the Court of Appeals thought there was something quite different about it. The Court of Appeals says this is going to be the test, not the other one. The Court of Appeals didn't think it was just an adaptation.
There are
So if you're right, why not we have to send it back to the Court of Appeals and say, think this one through again, and since we're not quite sure what was going through your mind, you'll have to put it through your mind again, realizing that this is just an adaptation of Abercrombie. Why don't we have to do that?
The difficulty is that no one really knows truly what the Abercrombie test is. The district court followed Stuart Hall, who cited Abercrombie, which has a test that states an object is protectable if it's tenuously related to the nature of the product.
You say we don't know what Abercrombie is?
Well, Willard
We
Beach,
seem to think so in 2 pesos.
Willard Beach, for example, cites several cases: the Chevron case,
Were we
the Seabrook
wrong in
case.
2 pesos?
In 2 pesos, the court cited the Chevron case, but that's only one of very many.
And we were applying Abercrombie. Were we wrong?
I think, given the court's later language in Qualitex, perhaps the court could have applied a different standard, but at that time,
But Qualitex endorsed Abercrombie and cited 2 pesos for the proposition.
I don't believe that's quite accurate, Your Honor. The Qualitex court, in fact, questioned Abercrombie. It stated that unlike arbitrary, fanciful, or suggestive word marks, a product's color, a characteristic of the product, was quite different. Consumers naturally look at an imaginary or fanciful word and they perceive it as a source identifier. On the other hand, when consumers look at particular product features, they do not immediately view that as a source identifier and rather see it as part of the good itself. But back to Mr. Justice Souter's question. The district court cited Stuart Hall, but it's not clear that they also employed, for example, the Seabrook analysis, which requires a comparison among other golf course designs. It's simply not clear what the district court did. Dorico, even if it has its roots in the Abercrombie test, specifically requires that both the unusual and memorable requirement and the conceptual separability requirement be fulfilled. It requires both, and there's just no indication in this case that the district court applied both of those standards.
Has any other Circuit Court of Appeals followed Dorico?
Only 3 Circuit Court of Appeals have reached the issue of the proper standard of inherent distinctiveness in product configuration cases. Of those 3, the Third Circuit has adopted Dorico, the Eighth Circuit has rejected Dorico and applies it's tenuously related to the nature of the product test, and the Second Circuit has also rejected Abercrombie and applies its own distinct test.
But were any of these golf course cases?
No, Your Honor.
And I take it that the net result of that lengthy recitation is that the answer to my question is no other circuit has adopted Dorico.
That is correct, Your Honor. Under either standard, really, the Abercrombie standard or the Dorico standard, the Willard Beach golf course is simply not inherently distinctive. For example, looking at the...
Do any of the other 13,000 golf courses use redbud and dogwood in combination?
Yes, in fact, they do, Your Honor. But first of all, I'd like to point out that Willard Beach has not offered any evidence in this case of other comparable golf course designs. So in that respect, it has failed in its burden of proof to to show that its golf course is indeed unusual. But for example, the Augusta National course very closely resembles the Willard Beach course. And in fact, several courses use redbuds and dogwood trees throughout the nation. If Your Honor wishes, I would be pleased to supply you with that information.
Only if it's in the record.
It's not in the record, Your Honor, but it may be judicially noticeable. Furthermore, the Willard Beach golf course cannot meet the unusual and memorable requirement. There are simply not features on this golf course that are not found in every golf course across the United States. Pine trees, sand traps,
Yeah, but
water hazards.
you're making the mirror image of the same argument that was made before. You're saying, look, there's only one way to look at golf courses, and that is to look at generic golf courses. They've all got 9 holes or 18 holes, and they've got a tee and so on. Why should we look at them that way, rather than looking at them as apparently the members of Golf Digest look at them, which is quite differently? It says this is the best one there is. Why look at them generically rather than specifically?
Well, I think we can look at them specifically, but in Willard Beach, there are no specific features that are unusual. It's quite unlike the Harbortown Hole 18 course in Pebble Beach,
Then
for
why
instance.
do you advertise that this is a replica of the most famous golf course in America?
Because it is indeed an excellent golf course. We would not dispute that fact. It is of quite high quality, but that doesn't make it distinctive in that
But
consumers...
isn't the distinctiveness in the combination?
Distinctiveness can be a combination, but there has to be something particularly special about that combination that will let consumers...
You mean distinctive plus special?
No, Your Honor. Simply the mere fact that one course is not exactly similar to another course or any other course is not sufficient to render it inherently distinctive.
Let's assume a golfer plays on your client's golf course. At the end of the day, if somebody says to him, "Do you remember anything about the course?" Is he going to say, "No, beats me"?
No, Your Honor. He'll
No,
probably...
he's not going to say that. And he's going to talk about the dogwoods and the way the ball has to make a curve at some point along the line if it doesn't go off into the rough. Those are exactly the things he's going to talk about, and those are exactly the things that qualify for distinctiveness, aren't they?
I don't think so, Your Honor. I think he will enjoy his golfing experience, consider it very pleasurable, but he will not think that this is Willard Beach. Clearly, Champions Greens...
Well, that wasn't the question. No one. I didn't ask whether he would have thought that he had been at Willard Beach. I asked whether he would have thought that there was something distinctive about the course that he remembered.
I think he would remember it in his mind as an excellent course. He would remember it for its features in the way that they contributed to the quality of the product itself. I don't think that the consumer would perceive the features as special in the way that they signify a particular source that is linked in the consumer's mind with a golf course. And that being the case, simply because the course is of high quality does not mean that competitors, that it's inherently distinctive and should not be allowed to be copied freely. I see that I'm out of time. Thank you, Your Honors.
Ms. Flynn?
Good evening. Mr. Chief Justice, and may it please the Court. My name is Laura Flint, and I represent the respondent, Champions Greens. I will address the proper standard for assessing the non-functionality of an asserted trade dress. I also will discuss the allocation of the burden of proof as to this issue. Your Honors, Section 43A of the Lanham Act regulates the market for a very limited purpose: to protect against consumer confusion and resulting harms to producers' reputations. That's why it protects source-identifying trademarks. The dangers of overextending trademark protection are greater when product configurations, rather than word marks, are at issue.
Because?
Because unlike word marks, Your Honor, product configurations often serve some significant purpose other than source identification. Some significant purpose that goes to the product itself, for instance. In this case, the layout of the Willard Beach golf course provides a challenging playing field for golfers. So there's
I'm sorry. No, please. Okay, so its challenging features are therefore the features that you emphasize. They are the functional features.
Well, the plaintiff is the one who is allowed to define its trade dress as it wishes, and here Willard Beach has defined its trade dress as the layout of the golf course as a whole. But certainly you could look to the individual features of the golf course and determine that they too are functional, and it seems that a plaintiff would need to provide some sort of reason why the compilation of various functional features would somehow become non-functional.
All right, you're faced, in making that argument, you're faced with an irony that your opponent has pointed out, I think. Your opposing counsel said the better the golf course, the more functional it is, and the least protection it gets. So if you want Lanham Act protection, by all means have a mediocre golf course, have one of the 13,000. But don't have a good one, because if you succeed, you're out. What's your answer to that argument?
Your Honor, if you succeed, you're out of trade dress protection, but you're not necessarily out of protection. The very purpose of the patent laws is to foster innovation. This court specifically stated...
How is that going to sort of help the corporation that owns the Willard Beach resort?
Well, it's not going to help them in this case,
No,
Your
they're going to
Honor.
be out cold, aren't they?
It is possible that at some point
But-
in time, they could have received perhaps a design patent on the layout of their golf course. At this point, it is too late for that. But the problem with overextending trademark...
Well, they didn't design it either. Would they have to get their protection simply as a licensee?
Well, it would depend on whether it was the corporation or Mr. Morse himself. He could license his patent protection to the corporation.
Mm-hmm.
The problem here is that the overextension of trade dress protection to product configurations does encourage producers not to meet the stringent patent requirements. Congress set out the patent regime and its stringent requirements in order to foster innovation, in order to move society forward and to provide incentives.
But that's an argument for saying that product configurations across the board should not be eligible for trade dress protection. Because any time you grant trade dress protection to any product configuration, you run up against that argument.
Your Honor, the two statutory...
So we were wrong in 2 pesos when we said that product configuration was eligible for trade dress protection.
No, Your Honor, this court was most certainly correct in 2 pesos. The
You don't know what a relief that is, Counsel.
Glad
Well,
I
it
can
is
help.
to me, sir.
And it is to me too, David.
But when 2 statutory schemes do come in conflict, as the trademark laws, the Lanham Act, and the patents scheme set up by Congress, as those 2 schemes do come in conflict, this court should construe them as consistently as possible. And in order to do so, it is essential that this court not allow producers to basically do an end run around the patent incentive system. Congress, in the patent laws, set out an incentive system whereby producers could receive short-term exclusive rights for their product. The trademark laws, on the other hand, provide essentially perpetual exclusive rights. So there is an incentive for producers to attempt to just sidestep the patent laws and not even apply for a patent, because it is a complex process, and simply get trade dress protection instead.
Well, if under your argument, if someone has to apply for a patent to succeed, what was the purpose of the Lanham Act?
The purpose of the Lanham Act, Your Honor, was to protect source-identifying trademarks and trade dress in order to protect against consumer confusion and harms to reputation. Now,
Are you saying product identification, product configuration can't be a source identifier?
it certainly can. The point of the functionality doctrine is to ensure that this end-run problem is as small as possible. So a definition of functionality needs to be set forth that eases the tension between the patent and trademark laws while still allowing product configurations that do serve as source identifiers to be protected by the Lanham Act.
Is functionality really an issue in the case? Let me put it to you this way. All right? Many courts have said that functionality is an affirmative defense. Now, I understand you have a somewhat different take on that. All right? But to the extent it is an affirmative defense, hasn't it been forfeited by the answer you filed in this case?
Your Honor, if you're referring to the fact that it was not specifically pled,
It wasn't pled at all.
under Federal Rule of Civil Procedure 15B, if the issue is not in the pleadings, but it is tried by express or implied consent of the parties, then the defect in the pleadings does not cause a problem in the case. Here, there was certainly implied consent if you look at the district court opinion and its explicit discussion of the issue.
You've been arguing that we ought to consider not one horrible but 2. I suggested one horrible to you when I said that if we accept your position, we'll say your position in substance on functionality, the better the course, the less the protection. You've come back to me and you said, well, there's another horrible you ought to consider, and that is if you don't see it my way, you're basically making an end run around the patent law. The two arguments seem irreconcilable. One thought that crossed my mind, since I confess I find this a very difficult case to understand, one thought that crossed my mind was one which has been voiced several times here, and that is we don't have to resolve those two irreconcilables because perhaps for reasons quite independent of the tests, this case does not belong under the Lanham Act at all. If that were correct, you would win. Why don't you argue that?
Well, Your Honor, we looked to the questions on which this court granted review and felt that we should address the questions that this court wanted to consider.
You did not regard that as being fairly comprehended.
I'm sorry?
You did not regard that sort of gut question as being fairly comprehended by the issues that were raised.
That is correct.
Let me just ask you, assuming that we took a more liberal view of what was fairly comprehended, let me ask you whether you would have an argument to make to the effect that the Lanham Act, for reasons other than one or the other of these two prongs of the test, should not apply to a case like this. And if you don't want to make that argument, I'm not going to force you to, but if you have one, now's your chance.
Two golf courses.
Yeah.
Your Honor, I think that almost every golf course that one could conceive of would be deemed functional, but I can think of an example of one that at least one golf hole, that might in fact be non-functional, and so in that sense might actually deserve some Lanham Act protection.
Tell me about it.
The Harbortown hole 18 in the Pebble Beach case that was referred to earlier in the Southern District of Texas was a golf hole that includes, first of all, just the regular golf hole layout, and then it had a lighthouse off to the side. That lighthouse certainly did not significantly affect the quality of that golf hole. It was just sitting there off to the side. And so that might be a golf hole, or at least something on a golf course that could be considered.
Well, I was going to say, that's the difference. It might just be the lighthouse that's protected and not the golf hole, and you'd still be between the two extremes with regard to the golf hole itself.
That's correct. It would depend, again, I guess, on how the plaintiff defined its trade dress in that instance.
Well, why wouldn't the signature hole here be comparable?
It would not be comparable because the dogwoods and the redbud trees on that hole do serve a significant function in making that hole more difficult, more challenging to play.
It also makes it more pleasing, doesn't it, and more attractive?
That's correct, Your Honor, and in that way that also might affect the quality of the hole and the mood of the hole and how the golfer feels when he or she tees off.
Well, you went so far, I think, in your brief as to say beauty is function.
That's right.
Marshall McLuhan of the Lanham Act here. In which case, any good-looking product or any good-looking configuration is simply out cold. No protection.
Your Honor, there is a possibility of protection for an attractive feature or an attractive configuration.
The lighthouse might have been just as attractive, wouldn't it? It might have been, but the test that we're asking this court to adopt today gets to whether a particular pleasing feature or configuration affects the quality of the golf hole or the product itself, such as to give a non-reputation related advantage. So it's unclear if people associated the lighthouse, for instance, with Harbortown the golf course, that might be a reputation related advantage, that they think the golf hole is more pleasing and the lighthouse somehow makes it a better hole only because they know it's Harbortown. Whereas in the case of the dogwoods and the redbuds, that really gets to a non-reputation related advantage. It creates the snowstorm appeal that makes it more difficult to play golf on that golf hole. Well, couldn't Champion have used some other kind of white flowers? Would that have caused the same problem?
Your Honor, that gets to the infringement issue and the likelihood of confusion. It's not clear that it would have made a difference in this case in terms of the actual outcome, whether it had used a different type of white flower, because there still likely would have been a the same issues at the infringement stage of the case. Now, the second goal of the functionality doctrine, after easing the tension with the patent and trademark laws, is to ensure that competition will not be hindered. The test set forth by Willard Beach is the availability of alternatives test, and that test does not adequately ensure that competition will not be hindered. It is not a clear rule, nor is it one that is easy to follow. In fact, to accurately apply it and actually determine what alternatives consumers would view as adequate substitutes for the Willard Beach golf course, courts would have to go through complex and arduous economic processes, which in certain contexts might be warranted, but in each and every trademark or trade dress case simply is not warranted. In addition, Willard Beach has not offered a principled way to draw the line between functional and non-functional in terms of looking at the availability of alternatives.
Have you given us a principled way to draw the line that's going to prevent beauty and challenge from swallowing up the entire law of Lanham Act protection?
Your Honor, the test that we're asking this court to adopt is whether a particular feature or configuration significantly affects the cost or quality of the product in a non-reputation related way. That does, in fact, ensure that some things will, in fact, receive protection under the Lanham Act. There must be a significant impact on the quality of the product, first of all. And second of all, it must be non-reputation related. In other words, take the example of, say, a Gucci handbag that has on the leather the intertwining G's that everyone associates with the Gucci brand. Now, people buy that product because they perceive it as having a high quality, but it's only because of the reputation of Gucci, not because they find some intrinsic beauty in interlocking G's on leather. So there would, in fact, be a distinction between protectable and non-protectable trade dress in that way.
Tell me, counsel, why you think the burden of proof on this issue, which may prove to be pivotal, should rest with the plaintiff rather than with the defendant.
Your Honor, this court should require the plaintiff to bear the burden of proving non-functionality because of the registration system set up by Congress, first and foremost.
Well, this court has never decided that, have we?
I'm sorry?
We haven't decided that.
Decided the burden issue. That's right, Your Honor. This court has not reached that issue in any case.
What would be wrong with the rule that would place the initial burden of showing functionality on the defendant once the plaintiff has shown inherent distinctiveness or secondary meaning or likelihood of confusion?
In other words,
should we adopt a rule like that?
Making it an affirmative defense? Well, the problem is that in the registration...
Once the plaintiff has shown the inherent distinctiveness or secondary meaning or likelihood of confusion.
Congress, in setting up the registration system, created an incentive system and a presumption of validity for those trademarks or trade dress that have been registered. One of the benefits of registration is a burden shift to the defendant as to functionality. So, by placing the burden on the defendant in every case, registered or non-registered, then one of the incentives for that registration scheme would be eliminated.
But by the same token, the imitator, or the alleged infringer, right, who has apparently assessed the protectability of the original product, seems to be in a far better position to offer proof as to functionality, since that inquiry should have gone through the infringer's mind, the alleged infringer's mind, before the act took place. And that also has a kind of nice symmetry because it avoids the epistemological quandary of requiring the plaintiff to prove a negative. So why aren't those fairly persuasive considerations for putting the burden of proof on your client?
Well, first, Your Honor, I just want to point out that, in fact, Willard Beach is asking this court to adopt a test that would place the burden on the defendant of proving the non-availability of alternatives. But in other contexts, courts do indeed require plaintiffs to show things that are formulated in the negative, such as in the patent context. An applicant needs to show the non-obviousness of the product. Likewise, in a contract case, perhaps, a plaintiff might need to show the non-performance of a contract. But in a trade dress case, it's especially appropriate because the plaintiff actually does have within its possession most of the information relevant to the trade dress inquiry.
Your time is up. Thank you very much.
Thank you.
Mr. Shanmugam, do you have rebuttal?
May it please the Court, if I can use the Chief Justice's phrase, I'd like to go for the jugular first and address the component of the Durico test that Mr. Pariser has identified as the most vital, the conceptually separable prong. In Durico, the Court explained this prong by saying that under it, a product configuration, quote, must appear to the consumer to act as an independent signifier of origin rather than as a component of the good. As a number of courts and commentators have noted, and Respondent acknowledges at page 15 of its brief, product configurations almost always serve an aesthetic purpose in addition to any potential source identifying one, and product configurations can serve functional purposes as well. As Judge Sotomayor said in the Kruger opinion, every producer hopes that it and its trade dress will be remembered because its design is pleasing, not because it is ugly. Because a Durico test would provide protection when a product configuration is only source identifying and doesn't serve any other purposes, the practical effect would be to render it virtually impossible for a product configuration to be protected. Indeed, of the 9 courts that have applied the Durico standard, the Durico Court, the Ames Circuit in this case, and 7 district courts in the Third Circuit, none has ever found a product configuration to be inherently distinctive. The practical effect would be essentially for the Third Circuit to reapply the standard that it applied for inherent distinctiveness before this Court's decision in 2 cases, namely by requiring secondary meaning in all product configuration cases. That simply flies in the face of this Court's holding in 2 cases. Turning, if I may, to the question of whether product configurations such as the layout at issue here are covered by the Lanham Act, I think the definition of trade dress to which I referred earlier from the John Harlan case clearly includes Willard Beach's layout. In defining trade dress as the total image of the product, the John Harlan Court defined that as including features such as size, shape, color, and color combinations, texture, graphics, and even particular sales techniques. The features...
But there was a product there. There's no product here comparable to it, is there?
There is a product, Your Honor.
What's
the product here is the golf course. It's a golf course without the additional distinctive features that we have here. Those features are the configuration. And those features stand in a dialectic relationship to the underlying product.
What do you mean by dialectic relationship?
Well, that's the phrase that was used by the Third Circuit in Durico.
I didn't understand it then either.
Well, Your Honor, that makes 2 of us. In Durico,
you withdraw the word, I take it then.
I would if I could. The Third Circuit applies that term with regard to packaging and says that packaging can stand in this dialectic relationship with the underlying product. However, the Third Circuit and the Respondent do not explain why product configurations couldn't stand in a similar relationship. I see that my time is almost up. For those reasons, the Court of Appeals should be reversed. Thank you.
Thank you, sir. We will recess until order can be restored to the court. We feel at this point in a moot court argument like the old judges, the real judges who delivered opinions from the bench. As you probably know, there are two philosophies of delivering opinions. One is to give the reasons first and leave the result for the end, which is essentially a keep 'em guessing theory, and sometimes surprise them greatly. And the other is to say where you're going to go and then explain how you got there. We are of the latter school of thought, so we're going to come to our immediate conclusions, and then we're going to speak for a few minutes about them. We have three specific decisions to make here, and I'm told that the proper order is to address first the best oralist. Our determination of the best oralist this evening is Amanda Tyler. Next comes the question of best brief, and our judgment on that was that the best brief was the respondent's brief. And finally, the best team overall, and the decision on that score goes to the petitioner's team. Now, we will engage in a short bit of legal reasoning, or at least legal reflection. Judge Kravitch?
Well, this has been a very exciting experience for me because, among other things, the arguments were all superb. I wish that on the 11th Circuit, every argument that we heard would be as good as the ones that I heard tonight. And this was an especially, I think, complex case for moot court. The Lanham Act is not as widely known and litigated as much as other issues. And it was a little difficult for me because I'm not a golfer. In fact, had it been ballet, I would have been more at home. But I can truthfully say that all I ever wanted to know about golf, I learned in this case. But it was, all of you were excellent. It was a very, very close decision and a very difficult one. I've decided many cases with a lot more ease than I did having to decide which were the best teams tonight. But all of you were just superb, and I know we'll have excellent careers ahead of you.
Justice Selya?
I can echo heartily everything that Judge Kravitch has had to say about the level of performance tonight. I approach this perhaps differently because I think it is fair to say that I'm the only member of the bench who is a golfer. Although very occasional, and the level of my expertise is best demonstrated by my colleagues' preoccupation with trees, which seems to be where I spend most of my time on the golf course. I thought that the quality of the problem was excellent. The quality of the briefs was very high, and the oral arguments, considering the complexity and difficulties that were inherent in the case, were uniformly exceptional. I sit here with fond memories of my own participation in this competition more years ago than I would like to admit, and I can honestly say that Harvard Law School has certainly come a long way I think you're a credit to yourselves and to your teams and to the school.
Well, I will echo much of what has been said. I should tell you that I have been at some moot courts, not in this law school, but I have been at some moot courts in good law schools, in which it was simply impossible to speak about the quality of the argument that we heard, as my colleagues have been doing this evening, and as I mean to echo in what I say. I think there is a tendency to suspect that there is a certain amount of politeness when we say that what we get in our courts is not uniformly at all as good as what we have heard this evening. But I can tell you from personal experience, and more exactly from personal practice, that is not a judgment which I deliver, or that any of my fellow judges this evening deliver out of politeness, and it happens to be true this evening. So all I can say is I hope to see you again on the other side of a slightly differently configured bench. So far as my reflections on this argument are concerned, I am very glad that we don't have to decide the law tonight. We had enough tough calls to make as it was. I personally found this an extraordinarily difficult problem to address, and I'm glad I don't even have to give you clues as to what I might do. But one sort of off-the-wall reflection crossed through my mind during the argument here. There was something occurred this evening that does not always occur, perhaps, I guess in my experience, fairly seldom occurs at these kinds of arguments, and that is the sort of the gap between the technical questions and a quite non-technical question which was passing through all of our minds and manifesting itself from time to time in some of the questions, and that was, what are we doing here with the Lanham Act at all? I quite agree with counsel, for example, on the respondent's side, who did not feel that within the terms of the questions they were presented with, as well as the ones we were presented with, that they could take the position that, in fact, this was simply a Lanham Act case based on considerations other than the two test prong question issues that were presented. And yet one couldn't ignore that broader question, and it certainly informed a lot of the more technical questions that we asked. My off-the-wall reflection was, however, that the stark contrast between sort of the big question that everybody wanted to ask and was trying to address, but without really coming out and saying it too often, and all of the other issues in the case would have delighted the late Sir Isaiah Berlin. At the time of his death last fall, I read several of the extended obituaries, and every one of them referred to what I suppose I was going to say was Berlin's most famous essay, at least the most famous essay along with Two Concepts of Liberty. The essay in which he explained the difference between intellectual hedgehogs and intellectual foxes. And he said, you know, the fox knows many, many clever things. The hedgehog knows one great big thing, and that's all he has to know, and that is what's going to happen if somebody bites him. There are hedgehog lawyers and fox lawyers too, because there are great big questions in cases and lots of clever technical ones. This was one in which the sort of the spirit of the hedgehog and the fox were contending in the course of the evening, and it's probably well to remember Berlin's metaphor that when you argue, you may be called upon to be a hedgehog and you may be called upon to be a fox, perhaps both. Some of us, at least, were trying to make you into both this evening. Lastly, let me say that the value of these exercises is not only the value that you may get out of it, or indeed even the law that we learn. And by the way, I'm not kidding there either. I've had 2 Lanham Act cases since I've been on the present court, and I had to dust off my rapidly vanishing knowledge just to get up to the line of scrimmage for this case. So all I can say is I wish we had a Lanham Act case coming at us next week, because I would be a terror. I would be a terror from the bench. But I'm not going to be that lucky. I was, however, lucky not only in, as we all were, in sort of the encouragement of seeing what happened here tonight, but I was also lucky in my colleagues on the bench. I was telling somebody before dinner this evening that my career on the First Circuit was regrettably, at least to me, regrettably short. But the one day that I sat on the First Circuit, I sat with a panel in which Judge Selya presided, and my predecessor on that court, Judge Bounds, made up the third. And I had worked rather hard to prepare for my first day in the First Circuit bench. And we began with as I recall, with a fairly complicated drug case with about 6 different defendants in it. It was kind of an organizational nightmare. And before I had opened my mouth to say anything, Judge Selya basically sort of took control of the case with his questions. And I thought I had worked out some fairly good questions to ask, and I decided after listening to a few of his to keep my mouth shut. That obviously did not inhibit me this evening, but I said to a friend of mine when the argument was all over, and I'd gotten home, I was talking to somebody on the phone, and I said, you know, I sat today with the circuit, and this is what we heard, and this is what went on. And I said, yeah, I really died and went to heaven today. And I can tell you it's good to be back sitting with Judge Selya. Judge Kravitch and I had not met before this evening, and I will remember this moot, among other things, for the fact that it was this evening that I made her acquaintance. At the risk of embarrassing her, I will tell you what one of my colleagues said when he found that I was going to be sitting on a moot court with Judge Kravitch this evening. He said, "Try to spend some time with her, David. She could help you." And I am satisfied that he was right. We will stand adjourned.